It takes some effort to make these videos. Please hit the subscribe to show your appreciation. Parliament passed a motion to review Section 25 of the Constitution, which deals with property and land expropriation. Parliament's Constitutional Review Committee is expected to report back to the National Assembly by the end of August. Section 25 states that property may be expropriated only for a public purpose or in the public interest, and, subject to compensation, the amount of which, and the time and manner of payment, must either have been agreed to by those affected, or decided by a court. The motion of expropriation of land without compensation, moved by J. Malema as amended by the ANC, is duly agreed to by the House with 241 that voted yes and only 83 that opposed it. What the amendment seeks to do is remove the subject to compensation bit. But what the ANC has never done is develop a land reform policy that considers just and equitable compensation from any standpoint other than the willing buyer, willing seller principle. Several legal experts have already pointed out that the two concepts are not the same thing. Under the current constitution, the governing party could still craft legislation with its own definition of just and equitable compensation that does not comply with willing buyer, willing seller, something the ANC has failed even to attempt in 24 years. However, the constitution already makes provision for land reform. It sets out the requirements that must be met when the government sticks its nose into private property rights. It gives the government the power to expropriate property, but only when it is for a public purpose.